Okay, so mostly I just want to offer a word of praise. I have been preaching the gospel of deliberate ambiguity in the Constitution-making process for many years, and I think you make a really important and novel contribution to that endeavor, so thank you. A question that I had that is a question of historical fact, I guess, and one that I assume at one point I knew the answer to and don't anymore, and that is, at what point in the convention was the Article 7 ratification process worked out? Because I think your argument is stronger if going into the process of crafting the language of the Constitution, the drafters knew that this was going to be an ultimatum game, and therefore they might have anticipated some of the moves that you're talking about. But if going into the process of drafting the language, it wasn't really clear yet, they'd kind of tabled or not really thought through the question of how are we going to turn this thing into law? How are we going to get this thing ratified? Then maybe it seems less compelling to think that particular language choices were made with an ultimatum game in mind.
I love this paper. I think the thing that struck me the most is wondering whether the practical consequence of your thesis is that we actually should interpret the original Constitution with a different method than we interpret the amendments. The amendments, they're ratified pursuant to Article 5, which has its own two-step process, right? But it's a pretty different one. There's no real agenda-setting advantage because of pluralism in Congress and because of the two-thirds requirement. And there's no real serious reversion threat, right? Because what we have isn't nearly as bad as the Articles of Confederation. But I'm not sure, as Tom suggested, that in another paper that the important amendments are any less ambiguous than the original Constitution. And so, I mean, it strikes me as kind of problematic that we might have, in effect, one interpretive approach for the original Constitution, where I think on your account there's a lot more room for construction and judicial creativity than we do for the amendments, where I take it there would be less room for construction and judicial creativity.
I want to hear about how, on the basis of it, you think about what I'll call the Madisonian waiver argument, right? Which is the idea, like common constitutional interpretation, Will and Steve's paper, the discussion I talked about it yesterday, which is that if in the convention, backers of the Constitution like Madison and Marshall say to their opponents, look, it doesn't mean X, right? That we should understand it doesn't mean X to be part of the bargain that is accepted, and therefore part of the agreement going forward. On your, one could always ask about that, what authorizes Madison and Marshall in particular to issue any particular waiver, right? And on your view, it would be a sucker's move for the audience to say, yes, we accept that, and it's going forward, right? On your picture, it seems like the anti-federalists should have said, well, he says that, and maybe that's right, but I'm not sure how he has the authority to disambiguate, and if I accept on this representation, I can't plead the representation later. I'm still on the hook for whatever the range of ambiguity might be, in which case, on your story, it's also possible that the rise of the Madison waiver argument as a standard moving common law later reflects actually the fact that the Jeffersonians win a lot of the arguments 10 years later, right? And they've disambiguated in that direction and then just point back to that as a reason why. I'd like to hear how you think about this.
Tom, thanks for the praise. No. On the question of historic fact, the Article 7 question, whether this is going to be ratified without a second convention, is literally debated at the end. Edmund Randolph, right at the end in September, I guess it's 17th, says, I would like to make one last plea for a second convention. Because he says, this is a cram down, it's not fair. And everybody says, boo, that will never work. So there's a sense in which throughout the convention, the question of whether there's going to be a cram down is hotly debated. Now, I do not know going in whether the Virginians who presented the Randolph Plan and others assumed that there would be a cram down. And so I'll just have to say, I really want to look that up and think about that. Peter, should the amendments be construed differently than the original Constitution? Absolutely, absolutely. And that means that when, for instance, we're reading, say, I don't know, the 11th Amendment, we might be very legalistic about it because there's an opportunity for all sorts of bargaining and deal making. There was no asymmetry of information, and there was certainly no inability to cut a deal about specific text. And so all the traditional arguments for textualism apply much more strongly to the 11th Amendment than they do to Article 1. And Richard, what force does Madison or anybody else, Randolph for that matter, have to waive traditional canons of construction or any other legal method and say, look, it's up for grabs after the ratification? Only this, I suppose, that this seemed the best way to get votes in those tight conventions of Virginia, Massachusetts, and New York. And they needed to win those. And so this was a tactic that they could use to say, to the extent that there's a debate later, and we come back to you and James Wilson you, because James Wilson was the one who was likely to nocitor socis them and expressio unius them. You can come back to us and say, that's not what you said back then in the ratifying conventions. We never had a chance to debate specific language or propose amendments. And so we don't think the method of construction is set. In other words, I believe what you should see from the Jeffersonians in 1791, 1794, and 1798 is that they felt every method of construction was up for grabs. That would be taking the presumption of strategic ambiguity seriously. And that's exactly what happens. Jonathan Ganap, I think, has explained it nicely. That essentially the words create a gigantic soccer pitch, within which you can debate. So executive power doesn't mean big pandas. It doesn't mean flamingos. It means something like executive power. But what executive power means is gigantically, capaciously defined. And within that soccer pitch, anything goes. The Jeffersonians like to be textualist. They love to go hyper narrow. The Federalists went all gigantically purposivist. And neither argument was foreclosed. And I think that in some sense, it's not so much that Madison has authority to waive, but Madison was inviting later arguments. So it would be difficult to refute if during the ratification debates you said again and again, look, it's up for grabs. It's simple general language. We don't know what it means.
One point, yes, I actually don't think it's true as Rick suggested both in his response and his comments here, that actually in the bank debate that there was a huge disagreement on the interpretive rules. If you actually look, they're all trying to look at pretty standard interpretive rules. Well, there may be a disagreement as how important a bank is. That's a kind of disagreement of fact. So I think that one really needs to do some serious work to see whether there is this kind of large disagreement. Mike and I have looked at that in a recent paper, and it's surprising the consensus on the kinds of rules that were applied, even by someone like Madison. Randolph, actually, who's also against the bank, pushes back on some of the one kind of odd rule that Jefferson applies. So actually, I think there's a sense of consensus about legal rules that surprisingly crosses the Jeffersonians and the Federalists.
I want you to say more about why the affirmative response to ambiguity should be a kind of all things considered pragmatism, as opposed to, and just to give one example of something you might give priority to, in the administrative law context with Chevron, we give deference to the first order interpreter, so long as they're reasonable. There's one way of reading McCulloch to be doing that, to say that Congress is the one that decides this, and that's what we should do. There's some reason to prioritize that kind of interpretive response over others, and I just wonder what you think of that.
Jeremy. Really enjoyed the paper. The procedural argument is a very useful supplement to Tom's work and others who've argued that there's strategic ambiguity. You present your paper as not so much a critique of the fixation thesis, but as a specification of when and why original meaning runs out. In fact, you claim that acknowledging the existence of strategic ambiguity is consistent with originalism. But I think that undersells the piece, or perhaps for some members of the audience, oversells it. The difference between originalists and non-originalists can be characterized as a disagreement about when and how often original meaning runs out. There's some consensus among originalists that there's sometimes very little space between interpretation and construction. Right? We don't have case law on whether a president can be 33 years old or whether Wyoming really needs 2 senators, although that seems like a relevant question. We have litigation about the provisions that you consider intentionally ambiguous. And there in the construction zone, I think you're arguing that originalism not only doesn't help, but actually misleads us into to the extent that the fixation thesis would lead us to think that we can fix meaning when fixing meaning is inconsistent with the original intent, right? Then I wonder if you would also consider, there's an argument that I was expecting to see here, but I didn't, and I was wondering if you'd come across any evidence of a non-procedural reason, but a substantive reason for why the framers wanted to leave things strategically ambiguous, which is that they actually thought that future generations might have knowledge and wisdom that they lacked, having the benefit, among other things, of actually having lived in a republic. They might have better solutions to these general problems that they were trying to raise. And then, if such evidence exists, that brings me back to Peter's suggestion and your response to it, then there's actually an argument that we should read the amendments just as we read the original Constitution. There's no procedural argument there, or there'd have to be a different kind of procedural argument. But the same sorts of arguments that the Constitution is intentionally ambiguous, and specifically the provisions we fight about, is still there with respect to the amendments.
I wanted to press you a little bit on 2 points. One was your repeated reference to the idea that the Federalists had to be sort of guessing to what the Anti-Federalists would say in response to the Constitution. You kind of inject this aspect of uncertainty that I'm not convinced about. So, for example, as Jefferson noted the first time he read the Constitution, 2 things leapt out at him. One was there was no longer a strong reserved powers clause like Article 2 in the Articles. And, as he put it, the strong inferences of the document cut against what Wilson had been saying in his State House Yard speech, namely the inferences from the sweeping clause, the preamble, all the dangerous clauses that Gannap describes as such. And I find it hard to think that the Federalists at the convention would have been surprised that anyone would have noticed the missing reserved powers clause and these dangerous clauses. I guess I wanted to ask you a little bit about that. And then also the Randolph Strategy. I mean, you frame the paper in terms of Federalists and Anti-Federalists. I wonder whether another way to think about the Randolph Strategy is it's a strategy of one brand of Federalists at the convention against another brand. So Randolph is idiosyncratic in some respects, but he's the governor of a state that he knows is going to have a hard time swallowing the Constitution in light of the way it finally shakes out. Virginia has much less control over the powerful government that's been created than he and Madison and others had hoped. So he's looking at it very much through that lens, but there are a bunch of Federalists at the convention who are very happy with the Constitution, with all of these features, and it shows in the way the thing gets ratified. So the Mid-Atlantic states all ratify without proposing amendments, as does Connecticut. It's only a subset of the states that are going to face the kind of problem that the Randolph Strategy is designed to address. And I wonder whether kind of incorporating that into the paper and the framework might help make the case a little bit more, as opposed to lumping it all into a strategy that all of the Federalists are supposed to be on the same page with respect to.
These are all terrific. Very quickly, Jamal, absolutely, you could imagine that there could have been some kind of consensus on second-order questions of who should resolve, who should liquidate, in the term of the day, the ambiguities. I actually think that the Constitution was deliberately and strategically ambiguous both about first-order questions and second-order questions. They could have easily said, oh, a council revision will answer these questions, or judicial review will answer these questions, or George Washington will establish precedents because everybody knows he's going to be the first president. They absolutely stay away from any of that stuff. Very few people will say, oh, this will all be settled by judicial review, the Supreme Court will handle this, or this will be settled in Congress. And that's why, for instance, later, Madison in 1798 can say, maybe the states can settle this question. You know, and so it's all up for grabs. And I think there's a reason for that. Had anybody said the way that constitutional ambiguities will be liquidated is by this person, Chevron style, Chevron for George Washington, it would have caused an uproar. John, on consensus in the bank debate about interpretive methods, I'm just going to rest on Jonathan Gnapp. I'm convinced by his argument that there was just a methodological profusion, that Federalists were making totally purpose-based arguments, and shocked, really shocked, that Madison would do two things. He would bring up original intentions, that he would say things like, I was there. He actually used the passive voice. He didn't say I was there, but people did talk about corporations in Philadelphia. They were shocked by that. And Jonathan Gnapp very persuasively says the idea of text as something not like the British Constitution, a mushy, general kind of statement of purposes, but text as confining with expressio unius and nocitur socis and, you know, the canon of consistent usage. That was just not how people thought about constitutions prior to Madison's and the Anti-Federalists and then the Jeffersonians making that a point. So I actually think there was no consensus, but take that up with Jonathan Gnapp. That's a battle of the John and the Jonathan. Jeremy, I think there's a huge difference between deliberate ambiguity and deliberate and strategic ambiguity. And Jeremy Waldron pointed this out to me. So quite often people will choose an essentially contested concept as part of a law, where they both agree about the general idea of the concept, and they actually have no conception at all about what the concept should mean in any particular application. And the point of endorsing a principle like reasonable or fair is simply to say, we'll work this out later without any conception right now about what will be fair in a specific circumstance. This is the conception distinction of Dworkin. That's not strategic ambiguity. Strategic ambiguity is where you have a very specific idea of executive power. You know exactly what executive power should be. And you'll be darned if you're going to say that to the other side, because you know if you were to articulate it fully, they would reject the Constitution. That's strategic ambiguity. It's, in other words, a concept that has a very specific conception, and you mean to endorse that conception, but you can't because you don't have the votes.
Of course, I read Jonathan's book, but he doesn't actually look carefully at the way Madison structures his speech. Madison leads with a variety of interpretive rules. He does indeed say, well, I remember this at the convention. When actually people object to that, he can continue that kind of argument. His rules are relatively regular for the time. And Randolph, again, rejects the argument. He's, of course, against the a bank. He rejects the idea of using people's memories to understand what the document means. So I think there's a tremendous consensus about actually how you interpret the document. And Jonathan, in his book, doesn't actually go through carefully the rules that are applied in the bank debate by the different actors in it. He's a historian. He obviously isn't as focused on what interpretive rules are as a lawyer would be in looking at these debates.
I'm not clear what Marshall's language in McCulloch has to do with the argument, I guess, and I would like to hear a defense of that. I mean, I think people overread Marshall's language a lot, right? I mean, he's talking about why we wouldn't expect to see the constitutional text list out a bunch of implied powers. I'm not clear what that tells us about whether this important substantive prerogatives that are enumerated are ambiguous. I'm not sure what that tells us about a reason to be strategically ambiguous. I just was not clear about why that matters. It doesn't seem to matter to me at all. And the second thing I wanted to ask about, and maybe I'm overreading this sentence, I think it was early on, one of the reasons for strategic ambiguity you mentioned was the Federalists didn't want to give up on their policy priorities, but they also wanted to paper over the issues so the Anti-Federalists would vote for it. How can both be true? In other words, I mean, maybe they can both be true, but I kind of need more explanation of that. If it's so ambiguous that the Anti-Federalists are willing to go along with it, doesn't that risk losing the Federalist priorities post-ratification when they actually start implementing this? And so I guess those are two things I wanted to see more of a defense of.
Rick, this has the structure of one of the standard arguments for Chevron. It infers from unclarity a decision to grant authority. That theory of Chevron is unrealistic about how Congress works. I wonder how realistic this is about the Federal Convention, because for it to be strategic and deliberate, does one of these have to be done sort of retail the way you describe the problem of what about incorporation? If we say that, the whole thing will blow up. If it had to be retail like that, and I think maybe it did, the Federal Convention wasn't long enough for that to have happened on all the many hundreds of issues that, as it turned out, this was true about. Whereas if you say, well, they made a wholesale decision not to make the document any longer, there are other reasons, like we're running out of time, and we can't do that.
I want to hear what you think about how this position that you're advocating fits into the just overall debate between, let's say, originalism and living constitutionalism and living originalism and so forth. So everybody's familiar, the argument's made all the time that some provision was meant to, it was deliberately vague, or it endorsed some sort of abstract principle or whatever, so that it would be possible for future generations to continue to interpret it, as in accordance with their understanding and the circumstances that they're in, and its meaning might change over time and so forth. Your argument doesn't seem to be like that at all. It seems to be quite different, and in fact, some of what you said here makes me uncertain about this, but the idea of strategic ambiguity seems like it's more something like, here's a provision that could mean A and it could mean B. We're not going to settle that here, but that might be settled, in maybe the relatively near future. We think you'll be more willing to sign on to this if we leave that open, but it's going to be settled, and it's nothing like a delegation to the future to just, continue to elaborate the meaning of this sort of thing in ongoing ways. So just what I said. So how does that fit into this debate again of, originalism, living originalism, and so forth?
Oh, great. I'm trying to write down what everybody says, but I actually don't know shorthand. I'm no Madison. Elon, I think that McCulloch paraphrases, absolutely very closely, Oliver Ellsworth's landholder paper, which was a response to the Massachusetts debate, where Ellsworth says, look, everybody's demanding that this document be clear, but the Constitution just can't be clear. Because now Marshall would say, it could scarcely be embraced by the human mind. And therefore, because we wanted to write a document that you Western farmers, like Amos Singletary, you non-legalistic people could understand, we kept it short and abstract. But that means we're not using the science of law, conventional canons. He specifically says that, John. We're not using conventional canons. They will not be used. This is absolute assurance that the Federalists would not play a trump card in whatever the form would be that would later resolve these debates. Because that was a constant worry of people like Brutus, Amos Singletary in the Massachusetts Convention, Patrick Henry, that basically what happens is we have a term that looks ambiguous, but James Wilson in his back pocket had some clever thing that he'd learned in Scotland about how to resolve this problem. And Ellsworth is saying, as one of the best lawyers, a very distinguished lawyer from Connecticut, I promise you we won't do that, or if you do, you can call foul and just do something different. So I think that McCulloch is repeating that assurance. Now you might say, well, why would the Federalists risk losing on all these issues by endorsing ambiguity? Because they could lose everything if the Constitution wasn't ratified. So this is a way that they could trade one risk for another. A risk of total loss for a 50% chance that they could lose in 1798. And by the way, by saying, look, this can be resolved any way you please, they left open the room for them to use legalistic methods. And maybe the people in 1798 would buy that. Or maybe not. Who knows? John, did they have a wholesale delegation to post-enactment folks? This is a difficult question. One of the things about strategic ambiguity is it's very hard to be clear about it. And they weren't clear in Philadelphia because it was a secret convention. And so I think they work out the position of strategic ambiguity gradually. At the Pennsylvania Convention, the Federalists play hardball, vicious hardball. Up to the point of not sending out copies of the Constitution to the Western states. They realize that backfires. When in New Hampshire, they almost lose and they have to cancel the convention. So at Massachusetts, they start playing softball. And I think it's at Massachusetts that Edmund Randolph's statements start getting circulated, and that they bring out John Hancock, who says, you can propose any amendments you want. In fact, we'll have a committee of 25 to consider amendments. And in general, the tone becomes, we don't know what it means. You don't know what it means. We're not trying to play hardball with you. And in all sorts of ways, large and small, from paying the expenses of the Western delegates and the Maine delegates, they're trying to show that they're not going to act like James Wilson and the Pennsylvania Federalists, who are widely hated as the minions of Robert Morris, and indeed kind of deserve to be hated because they played that ratification debate in a very viciously political way. So I think the Massachusetts State Ratifying Convention is the moment where it began to gel. The best way to sell this ultimatum game is by admitting this is an ambiguous document. And finally, Steve, I think one of the things they were ambiguous about is how quickly these issues would be settled. Caleb Nelson has this lovely essay, I think, article back in 2003, saying, they thought these things would be liquidated pretty quickly, probably in the Washington administration. That's certainly what the Federalists wanted, but they were ambiguous about that second-order question. And so you can imagine that there would be a quick consensus later on that these things should be settled quickly, and it's more important to settle them quickly than to settle them correctly. Or you could imagine that they would keep fighting back and forth. On some of these issues, they fight back and forth up on the corporate chartering question. It's not settled at all until 1862 when the Republicans take over and hand out charters to the Union Pacific Railroad. And even then it's not settled because by the 1913 Federal Reserve Act, you find, Richard and I are writing a little bit about this, that the idea that the federal government can delegate broad powers to private banks is regarded as quasi-unconstitutional. And so there's debates about what you can delegate to a private corporation up to Schechter Poultry, in which, of course, the Supreme Court finally weighs in on a question that had been debated for a century. I hope I didn't leave anybody out. But.
John, do you want to... another word about the question. I'm sorry. Another word about the question of the legal rules. I mean, I don't think that if you look at even the consensus in the debate, what Hamilton says in response to Brutus is not that we're not going to use legal rules. He says that we're going to use strict rules to constrain discretion. And it's hard to see how the Federalists could say something else about a document that seems to presuppose all sorts of legal rules, like in the Supremacy Clause. So it strikes me that it's not only what the people say, it's how they act, and they act, even in the Federalist Papers, by using all sorts of legal rules to argue what the Constitution means, but it's about the nature of the document itself. If there are legal rules that are embedded in it, like the Supremacy Clause, it's very odd to suggest, even in its normal public meaning, that people wouldn't understand this to be a document that would reflect legal rules. And then it's all, I certainly agree with you, there's some debate about what those are, but we don't actually have this incommensurability, and even in the way opponents view the Constitution in its legal context.
Very briefly, I disagree with nothing you say. Of course, it was all legal rules. The problem that the United States was divided into communities that viciously disagreed about what it meant to follow a legal rule. Saul Cornell documents this very well, but I would also commend to you the work of my colleague Dan Holzebach, who says that a legal rule to a Western frontiersman who didn't even have a copy of Blackstone was fundamentally different than a legal rule to James Wilson representing merchants in Philadelphia. The former regarded a legal rule as something that the local community would largely rule on, that they believed in jury nullification. They believed in custom as understood by the local community. A legal rule by James Wilson was a totally different thing. So the idea that everybody agreed that it was law in some sense resolves, I believe, absolutely nothing, given you have a legal community that's fundamentally fractured.
I think this paper represents a kind of common move that's made against, it's an example of a common move made against originalism, which is to claim that because the original meaning that is fixed is very, very thin, that leaves room for a huge construction zone in which discretionary actors have to make decisions, whoever they may be, down the road. But I think the way it works is by misunderstanding what originalists claim about the fixed meaning. The way it works is it trades on the idea that the semantic meaning of words is ambiguous, as you say, or vague, which I agree with John. You should spend more time talking about vagueness as well as ambiguity, but that's a side issue. It's just that the semantic meaning is ambiguous. And as an example of that, you give the debate, the disagreement between Jack and myself on the meaning of commerce. And you argue that, well, there's a dictionary definition of commerce that Jack relies on, and that introduces ambiguity into the discussion. And at that point, then we're in the construction zone, and things are kind of wide open. And I think the reason why you make this move is because I think you misunderstand the use of the word pragmatics in modern originalist theory. The way pragmatics works is it's not pragmatism, it's not practical consequences. Pragmatics is about contextual enrichment. It's about how the semantic meaning of our communications is enriched by the context in which it appears. So the word arms in the Second Amendment refers to weapons, not the limbs to which our hands are attached. Domestic violence refers to insurrections. It doesn't refer to spouse abuse. Quartering of soldiers refers to housing soldiers, not tearing them about, quartering them in some other sense. It's context that limits the ambiguities of these words. Now, some of that context is provided by the text itself, but other context is provided by the communicative content, the context in which the communication is being uttered. Like, for example, the debate between Jack and myself about the meaning of the word commerce. You would have to know something about what commerce, how commerce was used, what was the project of the Constitution in protecting commerce, in regulating commerce, in promoting commerce, and whether that, in that context, that one dictionary definition that made it more of social interaction, whether that actually was that would have been taken as a listener to be something that was included within the power of Congress to regulate commerce among the several states. Now, I'm in a room in which Scott Soames is here, philosopher of language, and Larry Solem is here, who know a lot more about this than I do. But I think that the construction zone, which could be very big if you limit yourself to semantics, is a much smaller thing when you limit yourself to contextual enrichment that is informed by what linguists call pragmatics, and it just isn't what you're talking about. When you use the word pragmatism or pragmatics, you're not talking about the thing that philosophers of language are talking about when they're talking about expanding the range of meaning and to include, and I guess the last thing I'll just say is, so what is that? This is not a philosophical argument. This is an attempt by philosophers and others to figure out, actually, how does communication take place? What is being communicated? It's a factual argument. It's an attempt to analyze a fact of the matter. Is the meaning of commerce all the dictionary definitions of commerce? Is that the meaning that's conveyed to a reasonable listener? Or is it a meaning more specific? And I guess the last thing I will just say is that I don't think there's much evidence at the founding, in any of the evidence that you cite, that this has been rejected and somehow they're trading on a much broader reading and then they're somehow going to get a political advantage from being less precise. But I'll let it go with that.
Just 2 points. You said that the goal of originalists is to eliminate most ambiguities, and at least for myself and at least others that I read who do sort of originalist history, the goal is to identify the genuine ambiguities. It's not to eliminate them. It is to eliminate some that may appear to be ambiguous. But even then, the difficulty is just trying to cut through a whole bunch of decades and generations of, we speak about, deliberate action, deliberate revolutions in American constitutionalism, whose actors, for good or for bad reason, knew they were saying we're going to out with the old, in with the new. But, or another way to phrase it is to identify those places in which the differences, say, between a Jefferson and Hamilton are smaller than the differences between Jefferson and Hamilton and us. Because particularly the revolution of 1937, which was called a revolution at the time by some of its friends, separates us so much further. So we're dealing with just a very different level of range of ambiguity. But it's not to purge them, just to identify them, and then to leave them as such. The second is the way you did. I appreciated your follow-up comment about the Massachusetts moment being a moment in which this kind of decision was made, because at the convention, I don't think it's fair to say you already have Federalists and Anti-Federalists. The convention was designed to be a consensus document, or at least it was designed to be something that would deal with the problems in a way that would be acceptable to a very broad swath of people. So yeah, there is awareness that there will be, certainly Rhode Island exists. Okay, there are people that really they know they're not gonna like what we're doing. But at least the impression I get is, I mean, this is a unanimous decision by Congress to send it out to the states. From their perspective, they're trying to build a consensus rather than beat back opponents.
I find myself wanting a better title. I think you should, something like kick the can down the road. I think you should, that phrase actually I think is evocative in useful substantive ways, but that's my least substantive thought, and it doesn't get much better from there, Rick, I'm afraid. I would agree, I would co-sign some of the observations from before that you may want to tone down some of the strong claims about information asymmetry or lack of information about what the potential likely opponents of the Constitution would actually have wanted. There are lots of contexts, domestic in the sense of within the states, at the national level, for that kind of information to flow through repeated controversies over the course of the 80s. I don't think that means you need to walk away from the claim entirely, and I would find myself tending to want to frame it more as an uncertainty about just how far they could push, right? Not like we are totally unaware of the 15 things they care about, but like just how much do they care about each one? I might reframe a little bit there. The most significant substantive question I came away with, which is this. You suggest that inadvertent ambiguity ought to be treated differently by downstream interpreters from strategic ambiguity. And I'd love to hear a bit more, even than you said in the paper, about why that's so. And relatedly, in a process which you rightly centralize and really usefully is central to how we think about these problems, where the strategic choices are made behind a curtain such that by the time the actual ratifying moment is happening, it's not necessarily clear to the ratifiers which ambiguity is which, right? How does that distinction map on reliably to a process where it's less plausible, at least possibly, to attribute a strategic element to accepting the ambiguity by downstream ratifiers who haven't been part of some of the really nice moments that you sketch of like walking away from being more specific in the convention itself?
Randy, thank you so much. That was a really helpful comment. I think in my footnotes I'm pretty careful to discuss the different meanings of the word pragmatic, and I think I suggest that I'm using Article 7 as part of that context, which can be used to resolve whether apparently ambiguous text is ambiguous. In other words, if you're aware of the Article 7 process and the ultimatum game it entailed, and you understand the political circumstances of constitutional ratification, then you will not make the mistake of assuming that Gricean conversational maxims or the maxims of ordinary legal interpretation, which were usual with treaties and statutes, should apply here. And so my claim is you can use the Article 7 context as part of the enriching context to figure out what this language means. And what I suggest in the part of the paper where I discuss you and Jack's discussion of commerce is, if you take Article 7 seriously and you understand the position that the ultimatum game and the reversion threat that it entailed put the Federalists in, then you will assume that there should have been maximum suspicion and minimum resolution in the meaning of the word commerce. And I point out that looking in the Philadelphia Gazette for uses of the word regulation of commerce or similar words, to figure out what the same words mean in the context of the Constitution might be actually stripping out a critical part of the constitutional context. Think of it this way. We're playing cards, and I say Trump. That doesn't mean Donald Trump, because we're playing cards. Well, now we're playing the Article 7 game, and I say commerce. In an ordinary statute, in a regulation, in a common law opinion, in the Philadelphia Gazette, in a diary, that might mean a very specific thing, especially if it's associated with the word regulation. But if it's in a game where you know James Wilson is on the other side, and that guy in 1786 said that the Articles of Confederation Congress had the power to charter a Bank of North America, an outrageous, ridiculous, crazy claim, and you know that guy's on the other side, you know anything could be claimed And so I believe that the anti-federalists absolutely were suspicious that commerce could mean regulating all kinds of social intercourse, which is precisely why Southerners were worried that the commerce power could be used to regulate what they called domestic institutions, which meant slavery. And so I don't think at all that it was beyond the pale for them to say, I don't care what it means in the Philadelphia Gazette. That's not the context here. And applying Gricean conversational maxims to this context just doesn't make sense if you understand it's an Article 7 context. That's my claim, at least. Now, I agree, David, that there was an effort to get consensus. But part of the way they wanted to get consensus was to forego binding later generations. In other words, I think one of their moves to get consensus was to say, you know what? This is going to be a very loosely written document. And that means that in 1837 or in 1862 or in 1913, the power of Congress over corporations could be resolved in a way that we can't predict. And so they were trying to preserve the opportunity, if we take them seriously, for later revolutions. In other words, they were just leaving it up for grabs in the same way that a Chevron space leaves statutory interpretation up for grabs. Except, at least in Chevron, in theory, we know it's a delegation to executive agencies. They even left up for grabs who it was a delegation to. And Julian, thanks for the idea of a title. Now I really want to kick the can down the road. That's really great. Here's how inadvertent ambiguity might be different. Inadvertent ambiguity implies that there's agreement about purposes, but we just couldn't choose the words. It's the Federalist number 37 claim that Madison makes, right? You know, we all basically know what we're trying to get at, but we just couldn't find the English words because this is a novel enterprise. What that means is you should look to 18th century purposes, pragmatic context, I think is the right way to use pragmatic in this context, to resolve the dispute. If you take strategic ambiguity seriously, you will not look to 18th century purposes because you will believe that there was not even agreement about basic purposes. There was a fundamental disagreement about the commercial and the agrarian republic, and any agreement about Lockean principles was so abstract as to be useless into baking any legal bread, which means that, for instance, FDR could claim he was standing up for the spirit of the Constitution because the strategic ambiguity means you can't even use purpose-based methods to resolve the ambiguity.
Does your position depend upon the framers at Philadelphia having understood that there would be a cram down prior to the end of the convention? I think it does depend on that, although I'm not sure. That's why it's a question rather than a comment. And my sense of the convention is that they don't even think about that question until the very end. Once they begin thinking about it, as you say, it becomes explosive. It's like the biggest issue at most of the ratifying conventions. But I don't think it. I think had it come to anybody's mind during the convention, it probably would have led to an explosion earlier, and there's no explosion. So I'm just thinking nobody even thought about it. And it does seem to matter because if the Constitution is drafted innocent of the cram-down problem, then I think a lot of your arguments don't really hold as much weight. Comment is it might, and this is just giving you more work, but there's a cram-down problem with the 14th Amendment too, much more obvious cram-down, since people who didn't even agree with the 14th Amendment ratified because it was a condition to being let back in Congress. So I think it might be helpful just to, since you're talking about the implications for interpretation of cram-downs, to use an additional example. And I've given more thought to that cram-down, and it seems to me that what follows from that as an interpretive matter is that it causes us to care a whole lot more about the intentions of the people with the power to do the cram down and to be less interested in what the public may have thought than we might in an ordinary constitutional situation.
I guess the two reasons to be skeptical about the strategic ambiguity approach. One is, so far as I can tell, the people actually talking about it in public describe the strategy as deliberate ambiguity rather than strategic ambiguity. That's Madison in Federalist 37, which you quote and disagree with. Seems very explicit. This is all just inevitable ambiguity, unfortunate ambiguity to be solved through liquidation, etc. And if everybody's being told that, I guess I wonder why that shouldn't be the presumption, even if it's false, even if behind the scenes they're being strategic and lying about it, shouldn't we at least hold them to their claim that this was not strategic ambiguity, but just sort of inevitable ambiguity. And my sense is that that is the rule for interpreting other law. Like, there are statutes that are cram downs. There are certainly treaties that are cram downs, where, two parties are at war and one of them really wants it to stop, and they'll sign anything to make it stop. And my sense is we don't suspend the ordinary rules of interpretation just because the Democrats crammed legislation through at the last minute, or somebody was winning a war. And so I guess as a normative matter, it seems like this is an especially bad case to abandon the normal rules.
I thought I understood what you were arguing and then realized I was more confused as time went on. So if this was strategic ambiguity, what was the crisp understanding of the executive power that they had at Philadelphia and hid from everyone? That seems less plausible to me than the claim that they wanted a word for this and just grabbed at one and used ambiguity deliberately. And the second worry that I have with the cram down picture is, this process, it's not clear that the Federalists were in any real sense in charge of the process, in the sense that Congress, the Continental Congress, votes to have people get together and talk about stuff. They do. They come back with a draft. It's really different than what anyone was expecting. Congress still decides to send it out for ratification everywhere. Why is it that this is a proposal by the Federalists? Clearly the people who are putting out the proposal think the proposal is a good idea. So in that sense, they're pro-proposal. But why does this have the sort of structural feature of cram down, as opposed to every state got to send delegates to the Continental Congress and decide whether they wanted to send this thing out or not? Why isn't this a neutral process?
Michael, you say, does your position depend on the framers knowing that there would be a cram down in Article 7? And that was asked earlier as well. And in the 15 minutes that I've had to think about it more, I think no. And here's why. It's what you see throughout the Philadelphia Convention is this kind of remark. Somebody comes forward and says, we should do this, and then other people say, ooh, that could be very controversial. And then they say, well, let's say nothing about it. I give the example, of course, at the very end of the corporate chartering power. But I claim that throughout, where should the capital be? Ooh, let's leave that up for grabs. What should be the qualifications for voters for the House of Representatives? Let's delegate that. There was a sense that they realized they could not resolve a lot of issues very specifically. I see you shaking your head, but I have it in my paper that I think the claim is, and I'm perfectly willing to defend it, they did not want to stake out positions that they thought would be dangerous. Now the question is, they have to decide how to sell it. And they have to decide whether to forego a second convention. That decision does not necessarily mean that they're going to defend the language as strategically ambiguous. They could send the exact same language into the states and then send a lot of James Wilsons to each convention and say, I know you think it's ambiguous, but it's only inadvertently ambiguous, and it can be clarified through lawyerly norms. I do not believe that they made that decision to sell it through strategic ambiguity until fairly late in the game. Now, I am aware, and this goes to Will's statement, that Federalist 37 is contrary to my position, and I say so explicitly in the paper. Federalist 37 is published in June of 1788. It has zero influence. It's a last-ditch kind of thing. It is one of several positions that is bandied about by Federalists. But I don't think it's the position that was the winning position. Now, I realize that that's somewhat of an indeterminate position. I say that I don't think the case for strategic ambiguity is clear. It's ambiguous. I think there's powerful evidence for strategic ambiguity, and many people pitch strategic ambiguity. I cite Ellsworth and Randolph. But I also think there's a normative case as well, and this goes to something else Michael asked or said. He said, look, if you have a cram down, such as with the 14th Amendment, that should cause us to care about the intentions of the drafters who are doing the cramming. Do I have you right that the crammers should matter? And I think normatively that's more or less indefensible. Why? Why would anybody think that that's a fair and deliberate process? One difficulty with saying that the intentions of the drafters should matter so much is it puts them in an extraordinary position to act as a dictator in an ultimatum game. Why would you find that normatively attractive? So if we're going to debate this as a normative rather than a positive matter, I would say I don't see any reason whatsoever why that position would be appealing to anyone or why you think it would stick. Put it this way, suppose we're litigating the 14th Amendment in 1900, and somebody says, you know who should govern the meaning of this document? Thaddeus Stevens, because, basically the Republicans were in charge and they crammed it down your throat, Alabama. Do you think Alabama's going to accept that? That they'll think it's legitimate or a great argument? My guess is they'll say, says you, normatively, we find that kind of offensive, and we don't think that the fact that it was an ultimatum that you shoved down our throat is a reason that therefore the dictator should call the shots. But I guess that's kind of a normative claim. Can't be resolved through historical sources, and so to the extent that you're persuaded that that's not a normatively attractive way of governing your day-to-day lives, ultimatum games where dictators say, I'll take 99 cents and you take 1 cent, you'll think I'm right and Michael's wrong. We have lots of experimental data about how people react to ultimatum games like that. And overwhelmingly, the reaction is that's not an acceptable normative position. Stephen, every state got to send people into Congress. That's an interesting point. Here's the thing. The Congress then agrees on a cram-down strategy. And the big question is, okay, so what rule of interpretation should go along with a cram-down strategy? In other words, again, an ultimatum game is proposed. And the big question is, what is the division of the dollar in this ultimatum game? And that's kind of ambiguous. The division of the dollar could be, look, this is a specific bargain in the John Manning sort of way. Lots of details have been worked out. We've made some confessions to the Anti-Federalists. We've kept some stuff for ourselves. It's a sort of a 70-30 division. That's one interpretation of the deal. If you have that interpretation, you'll take the John McGinnis strategy. You'll say, let's look at this through legalistic norms. Another interpretation of the deal is, look, we, the Continental Congress, are sending it to you because we need some kind of package. We need to maintain a national union. But as for the details, we can work that out later. This is a different kind of package. It's a lottery ticket. So the question is, what is it more likely that the Continental Congress is voting on? Lottery ticket or specific bargain? And we don't know because the Constitution doesn't say. It has a lot of apparently ambiguous terms. We don't know whether they're inadvertently ambiguous or strategically ambiguous. So I'm proposing a canon of construction to say they were sending a lottery ticket. That's exactly what they wanted to send. Now, I don't know if they thought about it very much. We don't have many notes from the Continental Congress. Langton Smith took a lot of notes. Well, not a lot, but a few. But on this question, he was silent. And so my guess is if you look at this context, my claim is, if you buy it or not, if you look at this kind of Article 7 ultimatum context, the deal that it makes most sense for them to sell is the lottery ticket. Because they just didn't have a chance to work out the kinds of specific bargains that would be acceptable to a ratifier who couldn't propose perfecting amendments. But, that's the claim. And it's really a claim that I make to Randy as well, that Article 7 is a special kind of context that suggests the best way to sell it was with a lottery ticket.
A little on what's attractive, because I think I agree in some sense with your response. It's certainly about the 14th Amendment. It wouldn't be very attractive to have Thaddeus Stevens, but I don't quite understand in your context why a kind of let's look at consequences, let's not look at things is very attractive to the Anti-Federalists, because their point isn't simply that, well, we're going to have all these clever lawyers. Their point is the federal judiciary is going to be interested in consolidated government. So insofar as we allow this kind of interpretation, we know where it's going to end up. So I just don't see why that has some of the same problems that you would see, let's follow Thaddeus Stevens, because in fact, the federal judiciary is sort of Thaddeus Stevens on steroids to those people.
Why do you think that I'm making the argument that there was an agreement, a second-order agreement, to have the federal judiciary resolve these things? That was also left up for grabs. They were strategically ambiguous about whether the judiciary would do it. No one, except for maybe James Wilson or some lunatic like that, would go around and say, oh, don't worry, it's all going to be resolved by Article 3 judges. No. They basically said, Edmund Randolph said, it won't be resolved by the federal judiciary. He suggested maybe the state legislatures would do it. But they basically left it up for grabs. And they even left up for grabs whether you should use pragmatism to resolve these things or purpose-based reasoning. And so you could be legalistic. You could say post-enactment, the best way to handle the meaning of Article 1 is to use Samuel Johnson's dictionary. Because that will, or you could use George Tucker's, the Tucker rule, and say everything should be resolved against the federal government. Say whatever you want, because we are not deciding now. That's the only bottom line. We decide nothing about the details now. We decide there's 3 institutions, we decide some very rough rules, and the rest is up for grabs. And so of course that's going to be attractive to the anti-federalists. Well, really, will it be? As I say in the paper, lottery tickets are scary, risk-averse people stay away from them. But under the circumstances, it's the best they could hope for. That's my claim. Because if they turn down this lottery ticket, they revert to chaos.